Hi, everybody. A very warm welcome to thorough newspaper analysis for the 21st and the 22nd of March 2024. Now, let's quickly proceed to the agenda for today. Today, we just have one Indian Express article to discuss. The title of it is How the Karnataka Government it has justified its hookah ban. This is an important article. Let's proceed and have an understanding of it. So, let's first see the context. देखिए 7 फरवरी को कर्नाटका हेल्थ डिपार्टमेंट ने एक नोटिफिकेशन इशू किया जिसमें उन्होंने कैटेगोरिकली बैन कर दिया सेल एंड कंजम्पशन ऑफ हुक्का एंड द ग्राउंड दैट वाज टेकन फॉर दिस बैन वाज public health. This notification also stated that hookah bars they violate fire safety laws and also they make the food items unsafe for public consumption. This article, this particular notification, it also stated that the violators, violators कौन होंगे जो let's say consume कर रहे हैं या फिर sale कर रहे हैं, there is somebody who's involved in selling and consumption of hookahs, they will be violators. So violator will be booked under a 2003 Act along with various state and central laws. The name of this act is Cigarettes and Other Tobacco Products, Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply and Distribution Act of 2003. Now, shortly afterwards, which is on 20th of February, the Karnataka government, it introduced a bill which proposed to prohibit the opening of hookah bars in any place along with other restrictions. So what has happened? पहले तो एक executive action हुआ, तो गवर्नमेंट ने क्या करा, नोटिफिकेशन रिलीज करा. अब ये एक लेजिस्लेटिव एक्शन है जहां पर एक बिल इंट्रोड्यूस हुआ है और इस बिल में ओपनिंग हुक्का बार्स इटसेल्फ हैज बीन मेड इलीगल and it is prohibited, as in this is proposed in the bill. The bill, it was passed the next day and amended the 2003 Act to punish anyone who opens a hookah bar in the state with 1 to 3 years imprisonment and a fine of up to rupees 1 lakh. This is the standing of the legislature. Now, because this has happened, so of course, those who are involved in the business of hookah bars, restaurants, and all of these people, they felt aggrieved. And as a result, they approached the Karnataka High Court, challenging this particular notification. तो उनका प्ली जो है, प्रेयर यही था essentially कि एक तो आप जो ये हाई डिपार्टमेंट की जो नोटिफिकेशन है, काइंडली प्लीज quash that. And secondly, also the petitioners wanted the court to direct the governments not to interfere in their business. The case, it was heard by a single judge bench of the High Court, and very recently, that is on 11th of March, the judgment was reserved. Now let's understand as to what is the arguments advanced by the counsels for the petitioners. So here, please understand, the lead petitioner is R. Bharat, and उन्होंने essentially ये argue किया है कि जो notification है, it amounts to illegal interference. Why? Because the only prohibition under the 2003 Act, it is on public smoking, on advertisement of tobacco products, and sale to underage persons. तो ये जो categories है जो कि illegal है 2003 के Act में, इसमें hookah smoking तो involved ही नहीं है, वो आता ही नहीं है. Why? Because hookah smoking, the petition pointed out, it isn't banned by the 2003 Act so long as it takes place in the designated smoking areas. So hookah bars mein kya hai? There are designated smoking areas. So because it is this activity is carried out there, so it is not illegal within the 2003 Act ambit. And this particular thing, that hookah smoking in certain designated areas, it is described under Section 4 of the 2003 Act. This was argued by the petitioner. Further, the petition also claimed that the Karnataka Health Department did not have the legal authority under the 2003 Act to issue the notification, whereas the petitioner has secured the necessary trade licenses and certificates to run his business legally. So he has the legal authority to run his business. But the state health department, it did not have the legal backing to issue this notification in the first place. This was another argument. अब दो आर्ग्यूमेंट्स एडवांस हुए हैं, आर्टिकल 19 एंड आर्टिकल 14, वन ईच. सो लेट्स सी. आर्टिकल 19 के रिस्पेक्ट में इट वाज आर्ग्यूड दैट the notification violates the right of business owners under Article 19, Clause 1, Subclause G of the Constitution, which gives the citizens the right to practice any profession or to carry on any occupation, trade, or business. अब जो बाकी सेपरेट पेटिशनर्स थे उनका ये कहना है कि ये जो पर्टिकुलर नोटिफिकेशन है इट इज वायलेटिव ऑफ देयर राइट अंडर आर्टिकल 14. अब आर्टिकल 14 की कैसे वायलेशन हुई? बिकॉज आपको पता होगा आर्टिकल 14 में हम इक्वालिटी का जो प्रिंसिपल है वो एंश्राइंड है, एंड यहाँ पर है कि आप जो अनरीजनेबल क्लासिफिकेशन नहीं कर सकते हो. यू कैन नॉट फॉर्म एन अनरीजनेबल बेसिस per a classification and discriminate against the members of that class. So similarly, they are saying that it is violative of their right under Article 14 of the Constitution by specifically targeting hookah activities while ignoring other tobacco and nicotine-based products like cigarettes, which are also regulated under the 2003 Act. So therefore, the High Court was, approached with the plea that you kindly please quash the notification and direct the government not to interfere in our right to business. Now let's see what is the standpoint of the Karnataka government. So the Karnataka government, it claimed that गवर्नमेंट ने बेसिकली ऐसे जस्टिफाई किया है कि हमारे पास लीगल पोजीशन है, वी हैव द कॉन्स्टिट्यूशन बैकिंग टू मेक लॉज ऑन द सब्जेक्ट जो कि इस पूरे मैटर से डील करता है, एंड बिकॉज हमारे पास लेजिस्लेटिव कॉम्पिटेंसी है तो हमारे पास एग्जीक्यूटिव कॉम्पिटेंसी भी आ जाती है. अब वो कैसे है? द स्टेट गवर्नमेंट क्लेम्ड दैट दे हैव द अथॉरिटी टू इशू दिस नोटिफिकेशन बिकॉज दिस एंटायर सब्जेक्ट it is under the heading of public health and sanitation, hospitals and dispensaries under entry 6th in the state list of 7 schedule. Now we all know state list में जो भी entries है वहां पर state has the competency to make laws. तो यहाँ से उनके पास law making power derive होती है. Now let's see executive power कैसे derive हुई. Moreover, the government referred to Article 162 of the Indian Constitution, which gives state government executive power in matters where the legislature of the state can make laws, thereby giving it the power to issue the notification banning hookah sale and consumption. The government also relied on Article 47, which is a part of the directive principle of state policy. Article 47 essentially क्या करता है? It places a duty on the government, on the state, that you put forth steps, you endeavor to bring about prohibition of consumption except for medical purposes of two things. What is that? Intoxicating drinks and drugs which are injurious to health. So government is sort of having a duty to make laws, to make policies which are intended at prohibiting such consumption and use. So Article 47, it is a DPSP. It serves as guiding principle for states and center to create laws, but it is not enforceable in itself. This, I believe, is provided for specifically by Article 37 of the Indian Constitution, which says that it is unenforceable in the court of law. However, it is fundamental, and the government, whenever it is making laws or framing policy, then they should keep into mind the principles which are the directives which are given by the constitution makers and by the constitution to the state. Now let's see how did the Karnataka government justified hookah bar. So ban. So on the specific subject of hookah bars, the state government claimed that there was no designated smoking areas in these establishments and claimed that the entire floors, they are marked as designated area for hookah smoking. Designated area can only be for eating. तो ये एक आर्ग्यूमेंट था ना पेटिशनर्स का कि why are you banning opening hookah bars? वहां पर तो they should be allowed, because we are just giving a designated space for people to smoke hookahs and consume it, and the rest of the area is used for dining and other purposes. So government here is saying that no, usually what is happening is entire floor is itself marked as designated area, and what is uh, reserved in essence practically to designated area, it is just left for eating only. Now let's see क्या बाकी states में भी similar ban है imposed. So for that, let's first see Karnataka government. It brought about an amendment in the 2003 Act by introducing section, the Karnataka amendment, I'm sorry, it introduces section 4A into the 2003 Act, which says no person shall either on his own or on behalf of any other person shall open or run any hookah bar in any place, including the eating house or pub or bar or restaurant by whatever name it may be called. Similarly, identical amendments in the 2003 Act, they were enacted in Maharashtra and Rajasthan in the years 2018 and 2020 respectively. Tamil Nadu legislature also enacted an identical amendment in 2022, and this is pending challenge at the Madras High Court. So this is going to be interesting for all of us to see as to what the High Court has to say on it. And with this, we've come to an end of the TNA. In case you want to get access to the free study material or the TNA slides that have been used in this video, please feel free to join our Telegram channel. And for the same, you know the drill. Click on the link in the description, or you may scan the barcode here. Thank you for being with us.